Good morning, everyone. First of all, I am thankful to Keshav, who has given me this opportunity to address you all on a subject of ethics and professionalism. Ethics and professionalism are not very seriously taken by the lawyers or the fields through which we work, and but I think that ethics and professionalism are very important part of a career of a lawyer in case he wants to become a successful career in profession of legal. In the changing world of legal practice, a high standard of ethics and professional conduct is the only tool that can ensure a stimulant justice system, and it would also restore the faith of clients in it. Considering that the lawyer client relationship is a fiduciary one, a breach of confidentiality can be punished. The areas covered by ethical standards include independence, honesty, and integrity. The lawyer and client relationship, in particular the duties owned by the lawyer to his or her client, includes matters such as client care, conflict of interest, confidentiality, dealing with client money, and fees. On the other hand, professionalism requires that you view continuing legal education requirement not as a burden, but an opportunity to become a better lawyer. Professionalism requires that you stay aware of new appellate decisions and maintain the resource necessary to conduct through legal research. Ethics in any profession are important. As you all know, it is perhaps more important in the legal sector where lawyers are viewed with a level of suspicion. The lawyers and their profession, particularly, have to be codified with regard to the ethics, and coding of ethics is crucial in ensuring the credibility of the practitioners and legal system altogether. It is a fact that law has been deeply linked to the growth of civilization. The purpose of law in society is to preserve the morality, sanctity that binds the society. A legal profession is considered a noble profession as it is the upholder and protector of law. Legal profession is a service-oriented profession which aims to serve society, and every young law aspirant who has attended law school is ushered into the fraternity with the opening lines in their orientation program, "Welcome to this noble profession." Justice Iyer quoted this legal profession, and I quote, "The most brilliant and attractive of peaceful professions with responsibilities both inside and outside it, which no person carrying on any other profession has to shoulder. An advocate has to deal with the greatest possible variety of human relations and has his mettle consistently tried from every direction. For the same reason, an advocate earns great social distinction, which ought not to be misused at any cost." Unquote. The underlying ethos of the legal profession is to serve the society, and the aim is to protect citizens from social diseases. The common understanding of law, as per the Oxford Dictionary, is that it is the system of rules which a particular country or community recognizes for regulating the action of its members and which it may enforce by the imposition of penalties. However, law is a more nuanced concept with different shades and complexities. It is an integral part of society as it reflects the accepted code of conduct that is prescribed or formally recognized by the community. The evolution of mankind has been intertwined with conflict, either with each other or against the community in general. Therefore, to preserve the social balance, laws were conceived as mutually agreed upon rules which the society would follow. Law has been deeply linked to the growth of civilization. The development of jurisprudence as a separate discipline shows the importance of philosophy of law. Law has also been studied from various lenses such as economics, sociology, etc. One common binding point is that they all converge on the fact that law is a reflection of society and its practices and beliefs. The purpose of law in society is to preserve the moral sanctity that binds the society. Therefore, the legal profession is considered a noble profession as it is the upholder and protector of law. Legal profession is a service-oriented profession which aims to serve the society. Rose Pound captured the essence of this sentiment when he wrote, historically, there are three ideas involved in a profession: organization, learning, and spirit of public service. These are essential. The remaining idea of gaining a livelihood is incidental. Lawyers are considered to be social engineers who bring about social change and development. The legal profession has been created to serve the litigatory needs of the public. Thus, the legal profession is not a business, it is a profession. In a profession, ethics play a big part. Lawyers throughout the world are specialized professionals who place the trust of their clients above their own and strive to obtain respect for the rule of law. They have to combine a continuous update on legal developments with service to their clients, respect for the courts, and the legitimate aspiration to maintain a reasonable standard of living. So, coming to the point and the topic as to what is ethics. Ethics is a very wide term, but principally, ethics are those moral principles that governs a person's conduct in a professional workplace. Ethics is a fundamental prerequisite in any profession and not just in the legal profession. Ethics denotes human behavior and their standard of moralities. Ethics are principles and values which, together with rule of conduct and laws, regulate a profession such as the legal profession. They act as an important guide to ensure right and proper conduct in the daily practice of law. Ethics are a system of moral principle and a branch of philosophy which defines what is good for individuals and society. I believe that the prime objective of ethics in advocacy is to maintain the dignity and integrity of the legal profession. Legal ethics ensure that legal fraternity serves the society honestly and to present each case in such a manner that the litigants have faith not only on the lawyer but also on the justice system. Some of the areas covered by ethical standards can be that a lawyer, as an advocate in particular, his duties towards the court, his competence, which encompasses academic qualification and training, meeting other practicing requirements such as holding a valid practicing certificate or license, conflict of interest, client care, confidentiality, dealing with client money, and fees. Every profession has its own code of ethics. The nature of professional ethics is such that it is the essence of the legal profession. It encourages a lawyer to act in a dignified manner that is befitting of such a noble profession. Thus, in order to maintain its dignity and integrity, professional ethics were codified by the Advocates Act 1961, which was implemented in the year 1961. Section 4 of the Advocates Act provided for the creation of Bar Council of India, and the various functions of Bar Council of India are defined under Section 7 of the Advocates Act 1961. Section 7(1)(b) of the Advocates Act empowers the Bar Council of India to lay down standards of professional code of conduct and its antiquities to be followed by advocates. Similarly, Section 49(1)(c) also empowers Bar Council of India to make rules for the standard of professional conduct to be observed by the advocates. Bar Council of India has framed Bar Council of India rules, and under part 6 of chapter 2 of the rules of this chapter deals with the standard of professional ethics and conduct of lawyers. Bar Council of India also prescribed certain duties that an advocate must fulfill during his professional career. The main intent behind these legislations is to prevent the exploitation of clients at the receiving end of their services, and of course to maintain the integrity of the profession. Just like every other provision and statute, these codes are not absolute in nature and can be amended or repealed as and when need be felt. Some of the ethics for a lawyer to follow and observe are upholding the rule of law and access to justice. If a lawyer do not adhere to and promote principles of justice, fairness and equity, the law itself is brought into disrepute and public confidence in the law is undermined, thereby hindering access to justice. Thus, the legal profession has a huge responsibility within society as upholders of the rule of law and protectors of individual rights against abuse of power. Another ethics which a lawyer should follow is to maintain the reputation of the legal profession. A profession's collective reputation is crucial to confidence that it inspires. The reputation of a legal profession is linked to how the public views the administration of justice. Where there is no public confidence in the legal profession, trust in the justice system itself is undermined. Another part is a major and very important part, and it is confidentiality. A well-established principle of ethics for the legal profession is that of legal professional privilege. Lawyers have a duty to keep affairs of their client confidential, and the circumstances that they are able to disclose client information is strictly limited. Then we have that a lawyer should always avoid a conflict of interest. A lawyer shall always loyally respect the interest of his client, and acting in the best interest of the client requires that a lawyer should avoid a conflict of interest. An advocate is also required to prevent his client from resorting to unfair practices relating to the court, opposing counsel, or opposite parties, or even co-parties. The advocate must earnestly restrain and explain the implications and the consequences of such unfair practice. This rule also empowers an advocate to refuse to represent a client if he/she insists on such improper conduct. An advocate must maintain a respectful attitude while at court and shall respect the dignity of the judicial officer. An advocate shall have his own sense of judgment, and he mustn't use strong language in the court of law. This is another important rule laid down, that the advocate is expected to have his own sense of judgment regarding the cause or the case he or she is representing. In a case of M.Y. Sharif and others versus Honorable Judges of Nagpur High Court and others, it was observed that an advocate is not a mere mouthpiece of the client, and a legal counsel must exercise his or her own judgment and should not show disrespect to a judicial officer. Another rule which a lawyer should follow is to always appear in a proper dress in a court, because a special proper dress code is defined for the legal profession, and it has its own designated uniform. The code demands that an advocate must necessarily show up in appropriate dress code, and there have been instances in court where cases have either been postponed or dismissed for that matter due to the lack of proper dress code that should have been followed by the counsel. Therefore, if an advocate is improperly or inadequately dressed, he is not only looked down upon, but also his appearance is a breach of the prescribed dress code. Another rule which a lawyer is required to follow is to refuse to appear in front of relations. This rule was laid down in order to avoid conflict of interest and bias in judgment. If there is a family tie existing between the presiding judicial officer and an advocate, then the advocate shall and should not appear in such cases and should always request for the change in bench. Another aspect of the rule is
Lawyer should
wear bands or gowns in public places. The advocates cannot utilize his or her gown or band in other public places unless in any ceremonial occasions that the Bar Council of India and the court may prescribe. An advocate is also prohibited to appear in matters of pecuniary interest. If an advocate has any interest, pecuniary interest in a particular matter, he should not appear in such matter. In some cases, it's seen that a client does not have a surety in a criminal case, for example. A client is required to submit a surety at the time of his bail, and he doesn't have a surety. In such a situation, a lawyer cannot stand as surety for his client. There are various other rules and advocates have towards their client, and in chapters 2 of the Bar Council of India rules, Rule 11 to Rule 33 prescribes the duties which are to be followed by the advocates towards his client. A lawyer can always appear in a court to attend a case of his client without any fee, and in case he has undertaken to do so, no action can be taken against him. But it is his duty that he should appear in his case at the time when the matter is listed for hearing. In a case of S.J. Chaudhary versus State, the Supreme Court held that if an advocate,
he would be liable for breach
of professional duty. This observation was based on the fact that a lot of advocates don't appear at the court, and then the client has to bear the brunt of the court. A lawyer is not permitted to withdraw from service without giving any reasonable and sufficient notice to his client before withdrawing from the case. If he withdraws himself with sufficient cause, he is bound to refund the fee, even a part of it, if not earned. Similarly, a lawyer can never appear as a witness where he himself, a lawyer cannot appear in a case where he himself has been a witness. Rule 13 of the Bar Council of India rules provide this, that it can give rise to a conflict of interest. It must be noted that if an advocate is a witness of a party and is asked to represent the other side, then such an advocate shall refrain from taking up such matters. This rule was approved by the court in a case of Konda B. Kondacha versus K.D. Ganapati in the year 1995. Under Rule 14, a lawyer is required to provide full and frank disclosure of the case to the client before the commencement of his engagement. He is obligated to reveal whether he has any connection with the other side of parties and any interest in their case. Otherwise, this creates controversies and also affects his client's judgment to carry forward such an engagement. Rule 15 provides that the lawyer should uphold the interest of his client and he should be loyal to his client and his should uphold the interest of his client fearlessly and honestly by all fair means. A lawyer should not suppress material or evidence in a case, because suppressing material evidence is absolutely disregarded in the court of law. This rule is provided under Rule 16, and it basically provides that if a prosecutor in a criminal trial tries to suppress material evidence that may lead to the innocence of the accused or taint the justice of the victim, it shall be considered a gross breach of professional misconduct and can also invite legal trouble. Such act or omission should be avoided. The advocate is further not to disclose the communication between him and his client, and this aspect is reproduced in Rule 17 of the Bar Council of India rules and is one of the most important obligations to be followed by an advocate. A non-disclosure agreement is always signed between the client and the advocate, and since there exists a fiduciary relationship between the client and the advocate, breach of confidentiality is taken seriously even by the court of law. Rule 20 of the rules provide that an advocate shall not charge depending upon the success of the lawsuit. Such a practice is opposed to public policy. Similarly, Rule 32 provides that when an advocate lends money to his client, then interest is created. Such a creation of interest, if not allowed, as it affects the advocate's sense of judgment and also disallows the client to think upon before commencing with engagement. Rule 33 provides that an advocate shall not represent the opposite party after withdrawing from the case on behalf of the previous part. As we all know, the fiduciary relationship between lawyer and a client is that of trust and confidence. Any client expects their lawyer to maintain a high degree of fidelity and good faith as their confidential information rests with the lawyer, as they need to know the detail of the case in order to find out the best way to pull their clients out of the legal trouble or query. In a case of VC Rangadhari versus D. Gopalan, way back in the year 1979, the Supreme Court observed that the relation between the advocate and his client involves the highest personal trust and confidence. Thus, their relationship cannot be completely treated as purely professional owing to the confidential nature of the information that the client gives to his lawyer. Thus, the lawyer-client relationship is purely fiduciary in nature. These are some of the ethics a lawyer should follow, and I personally feel that in case a lawyer, while discharging his duties, adapts these rules, he would become a fine lawyer in his career. The second aspect of our today's talk is professionalism. So, what is professionalism? Professionalism can be defined as the skills, competence, and the conduct displayed by an individual of a certain profession. It is also expected that such a person cultivate a polite demeanor when dealing with clients and fellow professionals. Professionalism encompasses a variety of dimensions. It is not only polite behavior or else academic competence. On the contrary, it is a mixture of number of qualities that contribute. Professional needs to have specialized knowledge in his particular field, and this is one of the main characteristics of a true professional. If an individual has gaps in his knowledge, the contribution that he can make is minimal. Being competent is also important. If an individual has all the academic certificates but still fails to work competently, then it is also disruptive to the individual as well as the organizational performance. The other traits of professionalism are honesty, integrity, politeness. This can be considered as one of the great assets of a corporate sector as it allows the individual to perform well. So, these were some of the traits a professional should have to be a good lawyer. And now I will talk about the attributes that will mark an individual as a professional. And in this regard, a lawyer and an advocate needs to be fully job oriented. He should have the competence. He should get the job done and done well. The ability should match the requirement of your role, and you should often produce results that exceed your expectations. Second attribute is knowledge. Professionalism involves developing detailed, up-to-date knowledge, which is often highly specialized. At every stage of your career, you can strive to master your role and keep adding to what you know. It's also important to put your knowledge into action. Being professional means feeling confident to show what you know, not for self promotion, but to help yourself and others to succeed. Another aspect is consciousness. In professionalism involves being reliable, setting your own high standards, and showing that you care about every aspect of your job. It's about being industrious and organized and holding yourself accountable for your thoughts, words, and actions. But don't confuse consciousness with working longer hours than everyone else or obsessing about details. True professionals plan and prioritize their work to keep it under control, and they don't let perfectionism hold them back. Another aspect of professionalism is integrity. Integrity is what keeps professional people true to their word. It also stops them from compromising their values, even if that means taking a hard road. Integrity is bound up with being honest to yourself and to the people you meet. Your beliefs and behaviors are aligned, and everyone can see that you are a genuine person. Another aspect of professionalism is respect. Professionalism means being a role model for politeness and good manners to everyone, not just to those you need to impress. What's more, you show that you truly respect other people by taking their needs into account and by helping to uphold their rights. Emotional intelligence is also one of the key ingredients of professionalism. And to be a true professional, you need to stay professional even under pressure. As we all know, the profession of law is a very stressful profession. There are a lot of pressures when a case is being taken by a lawyer and argued. So, this emotional intelligence needs to be taken care by take, making strategies for managing your emotions, plus a clear awareness of other people's feelings. In short, emotional intelligence is essential. Sometimes professionalism means keeping your emotions in check, but at other times, it's important to express your feelings in order to have meaningful conversation or to stand up for what you believe in. Another aspect of professionalism is appropriateness. A big part of being professional is knowing what's appropriate in different situations. It avoids awkwardness or upset and boosts your credibility and helps you to feel secure in your role. Appropriateness relates to outward appearance, such as dress, personal grooming, and body language. But it also covers the way you speak and write, the topics you choose to discuss, and the way you behave with others. Most important part of a professionalism is confidence. A well-founded confidence reassures and motivates other people, boosts your ability to influence and lead. It also pushes you to take on new challenges because you don't fear damaging any professional reputation if things go wrong. Professionalism makes you confident, but what you are doing now, but always eager to do it better and achieve more. So, how to exhibit professionalism? First of all, professionalism can be improved by improving your competence. To improve your competence, one needs to carry out a personal review of himself while identifying his strengths, weaknesses, opportunities, and threats. And thereafter, to set smart goals to plan your improvement. You need to increase your knowledge. As a lawyer, you have to be updated with the latest law. You have to improve your knowledge and skills. Make a commitment to build expertise and to stay up to date with your profession. Ensure that you are clear about the laws that apply to your work. Make it a habit to be polite and kind to everyone you come into contact with. Before drafting a case, go through the relevant laws, take a detailed briefing of facts from your client so that while preparing your case, you don't leave anything untouched while pleading. And up-to-date knowledge of law is a biggest tool for a professional lawyer. So make it a point that before sleeping, one should read at least one judgment in a day so that you are updated to the latest law. And even if you don't have a case concerned with that law which has been settled by the courts, still, if you have read that, then it can be of great use when you get an opportunity to deal that type of a case. So just don't sit back and wait that when a case will come, then only I will look for the law. But always try to read as much as you can, because that reading of law and study of law is the biggest tool for any professional, legal professional, and it will increase your personality remarkably. So now we can talk about what is the nature of professional ethics. As we all know that legal profession in India is highly competitive and dynamic. The nature of professional ethics is such that it is the essence of the legal profession. It encourages a lawyer to act in a dignified manner that is befitting of such a noble profession. Thus, in order to maintain its dignity and integrity, professional ethics were codified. It brings upon accountability upon the legal professionals for dishonest, irresponsible, and unprofessional behavior. Furthermore, advocates can lose their license to practice if they resort to unethical practices that endanger and tarnish the dignity of the legal profession. Now, a question would arise as to what is the difference between professional conduct and professional ethics. There lies a necessary distinction between professional ethics and professional conduct. The primary difference is between the obligation to be followed by a member of the profession. Professional conduct refers to acts or steps taken under some statutory obligation or contractual power. Such an obligation could be a legal obligation, and on the other hand, in professional ethics, one is expected to follow a moral obligation. The moral obligation is the integral part of professional ethics, and every lawyer should try to adopt it. Another issue which has to be addressed and which is being addressed at some levels is how to bridge the gap between legal ethics and legal profession in Indian courts. The traditional approach to legal education is that of the application of established legal rules and principles to a certain set of facts in a case. However, with the commencement of law over time, it was realized that the mere existence of law cannot bring justice due to a number of reasons. Firstly, legal services are not as affordable as it should be for the whole economic spectrum of citizens to be able to avail them. Especially in a power stricken country like India, the rights of poor take a backseat due to lack of affordability. Secondly, legal aid services are also limited. Thirdly, laws are not completely comprehensive and coherent, and judges are not consistent with their reasoning. Lastly, one of the biggest concerns is the lack of ethics portrayed not only by the police but also the lawyers. So the question arises that to bridge the gap between ethics and the legal profession, the codification of the standard of ethics was a way to prevent the above stated concern. But then another question rises as to how far is it successful in protecting the dignity of the profession. The institutions providing legal education often neglect the concept of ethical lawyering. Therefore, it is argued that in order to produce good ethical lawyers who would serve the interest of the country, it can only be possible if institutions provide legal education and educate young lawyers to be ethical. The legal curriculum must give importance to social legal issues and contemporary problems of society that can be solved through an ethical and realistic perspective of everything. Law schools are somehow uncharacteristically silent on the subject of duties to court and client and general responsibilities towards justice. On the other hand, it is argued that ethics cannot be taught, and it is up to every lawyer's personal experience that will help them develop such ethics. The problem with this statement is that it ignores the fact that before one enters a profession, he can be misguided. The traditional way of teaching professional ethics in Indian law school is not doing enough. Young lawyers need more insight into the fact as to why legal ethics is more important than subject knowledge. Legal knowledge can be gained much more than the knowledge gained in law schools through practice and experience. However, a sense of ethics should be developed earlier than that so that an intellectual legitimacy is created. Traditional legal education must take up a humanistic approach and shall try to impart values into young budding lawyers as their contribution to the future is going to become of great consequence. There must exist a more holistic and humanizing outlook towards the teaching and studying of law. Even after legal ethics are codified in India, lawyers still practice unfair means to seek favorable outcomes for their cases. The code cannot bring about a sense of ethics unless it is imparted to the law students at the very earliest. There are few positive examples where some progressive law teachers have recognized the need for law students to gain a deeper understanding of ethics and its needs in the legal forefront. With changing times, the existing methods used to impart legal knowledge need to change. There is a gap between legal ethics and legal profession. Thus, the vectors need to converge. The law schools need to understand that along with different disciplines in law, such as collaborative law, preventive law, problem solving, holistic justice, restoring justice, etc., all are meaningless if the knowledge is not implemented with morals, values, and ethics. In the end, I will just like to conclude that legal ethics and legal profession are closely related. It is from the existence of codified professional ethics for the legal profession that ethics hold an important position in the legal profession. The Bar Council of India ensures that advocates conform to the rules laid down with regard to legal ethics and dress code. The nature of the legal ethic reveals that it is an absolute mandate. However, the language of the code makes it evident that advocates owe a duty towards the bar, bench, their clients, along with opposing counsels at the court. The whole point of having codified legal ethics is to mandate advocates to maintain the dignity of the court. It also prevents the exploitation of clients, but mere codification of professional ethics will not fulfill the legislative intent behind the Advocates Act 9 and the Bar Council rule until the traditional method of legal education is slightly changed. Therefore, the code cannot bring about a sense of ethics unless it is imparted to the law student at the very earliest. So I think that the concept of ethics needs to be taught at the law school so that when a student passes law and enters the profession, he has that the knowledge of which he has to act as a lawyer by following all the ethics and also being a true professional in his career. Thank you. And I hope this lecture of mine would have helped all the viewers who are here to some extent, though it was not that much of an, because this topic is so huge that it contains a lot of things. So because of the shortage of time, I could just brief out all the important things which were there, which I could point out on the point of ethics and also on the point of professionalism. I hope you all must have enjoyed it. Thank you very much.
So, sir, thank you so much, sir. It was actually very well established and very well broken down point by point, the entire concept of ethics and professionalism. And I'm quite sure that, as I can see in the comments, that it has been very enlightening for everyone. So, there are a few questions which we have received so far. And
Yeah.
sir, if again, sir, time we have actually overcrossed the time, sir.
Yeah, that I was looking at the watch also.
So, but sir, it was so enlightening that it was very difficult to ask you to stop also. But sir, very briefly only, I think we have very little time only to take these questions now. So, sir, we have a question from Miss Madhavi who says, "Sir, I have a question. My question is, what are the steps complaint legal action, complaint steps slash complaint slash legal action to be taken against the advocate when he goes against his profession in the court?"
The first action which a client can take against a lawyer is, in case he has a grievance against his lawyer, he can file a complaint before the bar council, concerned bar council. There is a Bar Council of India, then there are bar councils of the each state. So suppose a lawyer is practicing in the state of Himachal Pradesh and a client has a grievance against him. He can approach the Bar Council of Himachal Pradesh by filing a complaint against him, pointing out the grounds on which he thinks that he has misconducted himself. And then the Bar Council of India, in its general meeting, takes up that complaint, and if it thinks that yes, a ground is made out for his misconduct, then a reply is called from the advocate, and After receiving the reply, a copy of that reply is given to the complainant, and the complainant is entitled to file a rejoinder to that reply, and thereafter the matter is again taken up by the general body, and if the general body thinks that a misconduct has been prima facie being proved, then there are disciplinary committees which are constituted under the Bar Council Act, and these Bar Council committees then take up the complaint, where the complainant gets an opportunity to adduce his evidence, argue his case. The lawyer also gets an opportunity to take up his stand, and then finally the committee decides as to whether a professional misconduct has been committed by a lawyer or not. So this is the procedure which is there for a client to take action against a lawyer in case he thinks that he has misconducted himself by holding his case.
So very briefly, just one other question I think we'll be able to take today. So this is from Mr. Pranav Sathi. Mr. Sathi, would you want to take a question yourself?
So I just wanted to know, is the right to practice for lawyers, is it absolute, or are there restrictions that can be imposed on us?
So as far as the Bar Council of India and the Advocate Act, there is no such bar. You can practice anywhere throughout in India. You can take up any other case, but the points which I have pointed out in my lecture, like you should not have an interest in a case, you should not have any relationship with the bench.
Right.
Such type of issues, if those are involved, then you cannot take up a particular case. Otherwise, you are not, you can take any case, which comes to you, but only there are few parameters which one has to keep in view before taking up a case. So there is no absolute bar.
Okay. So because some local, some courts insist that you engage a local counsel before you can, appear and represent your client's case before the court.
That happens in some cases. In some high courts, they have made a rule that a lawyer coming from outside needs to engage a local counsel, and that is only for the reason that sometimes, suppose a reply is to be supplied to the counsel, and in case he is an outstationed lawyer, then it would not be possible to supply a copy to him. So a local counsel is required to be engaged so that day-to-day proceedings can be undertaken by that lawyer. So it is only for that reason, but otherwise there is no specific bar that you cannot, you have to engage a local counsel in case you go to an outstation court.
Thank you, sir. Thank you so much. Thank you.
So again, sir, there are lots of comments. Mr. Abhishek has said very good oratory skills, good topics, sir. Then, sir, Mr. Harshvardhan Deshwar has said very valuable session, sir. And, sir, it just goes on. So
I'd just like to add, Keshav, though I know the time is very short, but to all the viewers, in case you get time, please indulge in legal aid cases. Legal aid cases is the best service a lawyer can provide, and it will give you immense pleasure and satisfaction if you will be doing legal aid. This is my personal request to all of the viewers who are present today, that try and do at least one free legal aid case in a year, and you'll come back to me and say that, sir, I really felt satisfied while doing that case. So I'll request everybody, all those who have joined us, that they should take up one legal aid case in a year and serve the real sense of the profession.
I'm quite sure that everyone is so motivated right now that most people will definitely contemplate, if not actually take up cases. So 2 words on such legal aid initiative as this community class, sir.
Legal aid is a very, very wide term. It's almost like a medical aid.
Yes, sir.
A patient goes, when you I am ill, you are ill, we always try and go to get to the best medical facilities which are available. And in case we fail to get that, we are really disturbed. Similar is the duty of a lawyer. We are all providing legal aid, though we may not see the impact of our working on the result which we get. But at the end of the day, the client is the real beneficiary. He is the one who suffers and gains because of the act of a lawyer. So, whenever you are taking up a case, whatever you are doing, please do it with a complete sense of responsibility and try and give your best while doing your case. Don't let even a single lacuna that you may repent afterwards, that in case I would have done this, in case I would have done that, I would have won that case. That opportunity is always available to you before going into the courtroom. So, before arguing, before cross-examining any witnesses, the basic work is your groundwork which you do. If you do your preparation well, if you have read your brief well, if you have read your replies well, you will always be able to put up a good show and you will win your cases for your client. I've seen lawyers, they don't even know, sometimes they don't even know the facts of the case. And the judges get so annoyed. The basic thing a lawyer can do is just be good on facts. A law can be applied even later on also. But if you are correct on your facts, right on your facts, the court will also try to help you. So these are few of the things which a lawyer should follow, and probably we'll have some another session on all of this some other day. So I hope everyone would have benefited from what I have said today. And thank you, Keshav. Thank you, dear. Thank you very, very much. And keep up the good work. It's really, really wonderful. And I think that this effort is going to help a lot of lawyers throughout the country, young lawyers. Lawyering, I feel that as a lawyer, you always learn. You cannot say that I know everything. At every stage of life, the moment you think that I know, a case will come up in front of you where you will have to start from the scratch. So, process, keep learning, keep reading. The best friend of a lawyer is the books.
So
And with this, I'll take all the leave from all of you. Thank you very much.
So very humbling. And sir, again, just very briefly, I want to thank you once again on behalf of the entire team, on behalf of all of the participants who have joined today,
Thank you, sir.
and all the people who will be seeing it. So everyone,
Thank you.
entire comment box is filled with praises for you.